Well, welcome back. We're going to talk about Chapter 15 now. We're going to be turning to mistake, fraud, voluntary consent. We kind of touched on this in the previous chapter. I did mention a few times undue influence and duress as being able to destroy a meeting of the minds or mutual assent. And this is going to really bring some of those terms into sharper definition. It's going to give for us a proper understanding of the difference between duress and undue influence. Now, before I start this, I'm going to be talking quite a bit in this chapter about the criminal law and the civil law. And we're mainly here in business law concerned with the civil side of it, which obviously has a different standard of proof. That is, proof by preponderance of the evidence is the civil standard. It has a different outcome. In a criminal trial, there is incarceration, often fine and court costs, but incarceration, probation, even potentially in the worst case scenario, execution. Civilly, it's much more about the establishment of damages. So I'll use these two terms. I'll talk about civil, I'll talk about criminal at the same time, but be aware that we're mainly concerned here with the civil side of it. I will, however, distinguish between the two. Okay, jumping in then. Let's talk about mistake. Let's use as our example going forwards if we're talking about a buyer and a seller. And we're going to talk about the buying and selling of a valuable book. So the first book that was published in the Western world that was widely circulated, at least that we know of, was published in the early part of the Reformation. It's called the Gutenberg Bible. It was a copy of the Bible translated into German and published on movable type. So these books, as you might imagine, are exceedingly rare. And very often, when they're sold, they can sell for tremendous amounts of money. So in our examples going forward, we're going to be talking about the buying and the selling of a Gutenberg Bible. And we're going to say that the value of a book, at a kind of arbitrary but high figure, is $1 million. That's what a Gutenberg Bible in the condition that we're selling it in would go for. All right, so let's talk about errors that could creep in and how they would affect. Let's suppose we're going to talk first about a unilateral mistake. A unilateral mistake is made by just one party. You're selling a Gutenberg Bible, I'm buying a Gutenberg Bible. I believe that the Bible was published in Stuttgart, and you, in fact, the Bible was published in Berlin. Okay, so I go to buy the Gutenberg Bible. As part of my reason for buying it, it's Stuttgart is the city where it's published, and I make a mistake. I believe that this particular Bible was published in Stuttgart, when in fact it was published in Berlin. So this affects the meeting of the minds here. This affects the assent. The question becomes what impact that has. All right, so let's ask a question. Is it important what city the book was published in? Now, the general answer to that is going to be no. It's not important. If it's not important, then we don't even go any further. Sometimes we're going to use the term a little bit later, material, but if it's not an important thing, we don't care about it. But again, for the sake of argument and illustration, let's suppose that this is a mistake, and it's an important mistake, and it's made by one party. So let's go back to the beginning of our example. As opposed to city being important, let's suppose I go into your bookshop. The book being sold is an old German Bible. I believe that it is a Gutenberg Bible and very valuable. You know that it's not, that it is just an old German Bible published near the same time. I purchase it believing that it's a very valuable Gutenberg Bible. Now remember, we said a Gutenberg Bible would be worth $1 million. I buy it from you for a relatively low amount of money, $100,000. You sell it to me for what an old Bible like that might be worth, $100,000. I think I'm getting a great deal. I think, oh man, I'm getting a Gutenberg Bible, which is worth $1 million for just $100,000. So I have made a unilateral mistake. This is a mistake on the behalf of one party. The general rule the law is going to enforce here is, too bad, so sad. You live with the consequences of this, Jay. You made the mistake. The seller never represented it was Gutenberg Bible. It just listed it as Old German Bible. So general rule for unilateral mistake is no harm, no foul. Now, if the other party knows the mistake, and maybe we're going to I represent the book for sale as Gutenberg Bible. You believe it's a Gutenberg Bible. In fact, it isn't. This is just an error on both our behalves. It's an old book, but it's not a Gutenberg Bible. Then we have a bilateral mistake, and we have a different situation. We're going to address bilateral mistakes in just a minute. Now, if there's a small mathematical error, we can sometimes go back and correct it if it's on behalf of just one party. But generally, unless it rises to the level of gross negligence, not something that concerns us. Okay, so a bilateral mistake. I sell you a book believing it's a Gutenberg Bible. You buy a book believing it's Gutenberg Bible. I have an honest belief that, yes, that's what it was. You have an honest belief that, yes, that's what it was. Turns out it's not true. I didn't try to cheat you. I sold you what I thought was a Gutenberg Bible. I sold it for the correct price, $1 million. You paid the correct price for it, $1 million. Turns out it's not a Gutenberg Bible. What do we do? Well, in a bilateral mistake, okay, we simply rescind the contract. You give me the book back, I give you the Bible back. I give you your money back. Now, one of the questions I get is, well, what if there is a mistake as to value? So I come in to buy an old book. Remember that example. You're believing it's Gutenberg Bible, or I believe it's Gutenberg Bible. You know it isn't. You're selling an old German Bible. You sell it for $100,000. I buy it for $100,000, thinking it's worth $1 million. We made a mistake. Okay. Even if you overpay, so selling a Bible, you pay $1 million. That's more than the book is worth. I never represented it was a Gutenberg Bible. You made a mistake as to the value of it, and you purchase it. It's treated, you see, like an underlying unilateral mistake. Now, if it's bilateral at the base, we both believe it's one thing and it's not, well, then the value arises out of that. Then we can have rescission. But if it's a unilateral mistake that affects the value, there's no rescission. Again, you live with the contract. Now, the next stage is not the seller honestly believing that it's worth that and the buyer honestly believing it. But in this stage, we're going to have someone commit fraud. Now, this is the first, remember when we started introduction, this is the first time that we're going to begin to encounter the criminal law, because it can be criminal to commit fraud. It is also civil. Very often, depending upon the nature of the fraud, it could rise to the level of you could be arrested and charged with a crime, or simply charged with a crime. But that doesn't do us a lot of good in business, because remember, if you get convicted of a crime, if you committed criminal fraud, well, that's bad, but criminal fraud doesn't necessarily say, okay, pay the guy who you ripped off his money back. So we're going to stick on the civil side of fraud here. We're going to stick on the tort side, because if you win a tort case of fraud, you can recover your money. So what is fraud? Well, fraud really, on the civil side, is going to have three components. The first component is you've got a misrepresentation, okay, of a material fact. Okay, again, you come into my bookshop, and I have in the glass case a Bible that is labeled Gutenberg Bible. I know it's not. I know that this is a later book and that it's not worth $1 million. But I'm trying to sell it as a Gutenberg Bible. So the first condition is a misrepresentation of a material fact. Now the whole point of buying this book is because it's a Gutenberg, and it's not. So obviously that's an important fact. But if I had a book under glass and it said Gutenberg Bible, April 1835 edition, no, let's not even do that. Gutenberg Bible published in Stuttgart. And in fact, it wasn't published in Stuttgart. It was published in a very small town just outside of Stuttgart, Germany. Well, that wouldn't be an important fact. So even though I might lie about it, and if you purchased it, unless it impacts the value, it's hard to see how that's important. But let's go back to an example of fraud. I have a Bible that's not a Gutenberg that I'm representing as a Gutenberg. So now we have the misrepresentation, and it's about something important. So the second component of fraud is that I do this with the intent to deceive you. If I just had this as a advertisement in my window, if I just said, oh, rare Gutenberg Bible on tour, and I have it sitting out there and it's not a Gutenberg Bible, I'm not even trying to get it to sell to you, then yes, we have a misrepresentation. Yes, it's of an important fact. But the second condition, I'm not trying to deceive you and get you to rely upon that deception to buy it. So let's continue with an active example of fraud. I'm representing something as a Gutenberg Bible. Why did I do that? Because I want you to rely upon it, and I want to deceive you. The third part is you rely upon my representation, and that reliance is reasonable. You could ask a fair question. If you're going to buy an old book for $1 million, believing that it's worth $1 million as a Gutenberg Bible, unless you are somehow an old antiquarian book purchaser, unless you would know, don't you think it would be reasonable to have an expert look at it? Well, you know, a court might look at this and say it's not civil fraud because you really should have had someone looked at it. The other person made a misrepresentation. They did it to try to deceive you, but you really fell down yourself. It doesn't mean you couldn't sue for damages necessarily. It would mean that it might not be fraud. Here would be an example that we could look at that might make it clearer for you. You're buying a new car, and they misrepresent in the salesman. He's talking to you. He says, this car gets 100 miles to a gallon. Okay, and the reason you're buying it is you're going to buy it as a commuter car. Well, that's great, 100 miles a gallon. I'll barely use any gas. So they lie. The car, let's say, only gets 10 miles per gallon. They lie about it. They're trying to get you to rely upon that. So we've met the first two conditions. You rely upon what the salesman says, and such reliance is reasonable. Well, you know that in pretty much every car newly sold in the United States, there's that little sticker on the side that in big bold print has the number of miles per gallon. So if you had just stuck your head around the side and looked at the sticker, it would have said 10 miles per gallon, and you would have known that the salesman was lying. In that case, we would have met the misrepresentation of an important fact, the second condition with the intent to deceive, but we would have failed under the third one because your reliance upon that was unreasonable. So you've got to meet all three of those to get fraud. Okay, how does misrepresentation occur? Well, it can be by actions or it can be by words. So you could, for example, provide a sample. That would be an action. You could say, this is what the inside insulation of this wall looks like. Well, short of me opening up a wall, how would I know? Now, I'll give you words for it too, but let's suppose I just left out a sample, and it looks like, wow, that's a lot of insulation, but in fact it isn't. So you can have a misrepresentation by saying it, essentially lying, or by showing it falsely. Now, misrepresentation does not include a future fact or a current opinion. So, example here. If I say, if you buy silver today, or gold, it will I think it's going to go up 100%. I think within a year you'll probably be able to sell it twice as much. Well, I'm claiming that this is going to occur in the future. It may not. It's generally not going to be a fraud. If you say, this is the sweetest little car in the world, or this is the nicest representation of a Gutenberg Bible, well, there might be others. That's kind of an opinion. That's really not going to be something for which we can have a misrepresentation or fraud. Now, we can have misrepresentation by conduct, by action, as I said. And usually what you're doing there is you are concealing a fact that's not readily apparent. What happens if you misrepresent the law? So I tell you one thing. If I tell you, well, you can buy this Bible here in Germany and you can import it back to the United States. But in fact, Germany has export controls. Many countries do. If they have a national treasure, something that was produced in that country, you can own it in that country, but you usually can't take it out of that country. So you buy this book in Germany, and you're getting ready to fly back to the United States, and lo and behold, you can't. At the airport, they say, well, we're not going to seize the book, but you can't take it out of the country. You purchased it because the seller made a misrepresentation about the law of export. That is generally not a misrepresentation you can sue under, because there is a presumption that all parties know the law. Now, there could be an exception here, like everywhere there's exceptions. If you were dealing with a lawyer, one party who's supposed to know the law, if you said, do you have a lawyer on staff who could confirm I can export this? And the guy goes, oh, yeah. Let me introduce our lawyer. This is John Smith. He's a lawyer. John, tell him they can take the Bible out of the country. And John Smith, who's a lawyer, says, yes, I'm a lawyer. I will tell you that the export law doesn't cover Bibles. You can take it out of the country. In that case, it would be a misrepresentation because of the law, and it would be covered. Can you have misrepresentation by silence? And the answer here is, typically, I have no duty to disclose a negative fact. I do not have to tell you everything. I can remain silent. It really is. This goes back to an old Latin phrase, caveat emptor, let the buyer beware. You're supposed to check out what it is, and make a good decision. Now, you may query me, you may ask, okay, about a negative thing, and if I lie to you, we've got a misrepresentation. But let's suppose there's an underlying problem with this Bible. Let's suppose that it's missing 3 or 4 of the. Let's suppose it's missing the Gospels. That the first 4 books of the New Testament have been cut out. And you look at the Gutenberg Bible and say, oh, that's really nice, it's very lovely, and you look at it, and you flip through it, and you don't see that. Do I have to tell you they're missing? And the answer there is going to be, no, I don't. Now, if there was a serious defect that was difficult or impossible to detect, then you may have to disclose the problem. So I'm selling you the Bible, and as opposed to it missing whole chapters, there's 2 pages in the Bible that are missing, which would dramatically affect its value. It's not a perfect specimen. Well, it's probably unreasonable for someone to look through a 10,000 page book by themselves, each page being present. So me not telling you that it's missing 2 pages, which might change the value, say, from $1 million to $900,000, that might be on you. All right, we're going to introduce a term here that I really like. That term is sinister. Sinister is when you make a statement that you know is false, okay? And it's got to be a fact. Now, sometimes you do not even have to prove that the other side knew it was false, just that they made a false statement. The most common time you see this is when you are relying upon a professional's duty to know the truth, and he makes a representation. So you take it to an antiquarian bookseller who is an expert, and the antiquarian bookseller who is selling the Bible says, in my expert opinion, this is a Gutenberg Bible, and he's wrong. Okay, that could be sinister. because being a professional, he should have known. If you make a statement that you believe to be true and it's not, it's generally not fraud, okay? And the remedy is rescission, returning the parties back to the original condition. Sometimes, if you didn't exercise reasonable care on what you should have known, it becomes negligence. Now, the important difference there is that Senator will sometimes let you recover damages. Well, if it's an innocent misrepresentation, you're only going to get rescission. Any reliance has to be justifiable. More commonly is if there's no easy way of checking on the representation, then it's safe to rely upon it. But think again of the sticker I described on the car. You do have to have injury. Now, you usually don't have to actually show injury to rescind a contract. But if you're suing under fraud, it can result in an injury. Like you bought my Bible that you paid $1 million for, and it turned out it's not real. Because you bought this Bible, you passed up on another one that was as good or better. And now if you want to go and buy that one, it's not going to cost you $1 million, it's going to cost you $1.5 million. Well, I could sue for the damage. Rarely, and this is usually when we're getting closer to duress, undue influence, active fraud, you might get punitive damages, which are damages designed to punish. You might be able to recover large amounts of money. All right, so let's go to the next step. We've kind of had the innocent misrepresentation. We've had the fraud, which has a misrepresentation in it, but it's intentional. Now let's go to an undue influence. Undue influence, first of all, starts off with a special relationship between the two parties. So, example, I am a licensed attorney, or have been a licensed attorney. I recently retired. But I have a mother. And let's suppose I go to my mother and I say, Mom, let's write your will. Now, I am both her son, but I'm also her attorney at this point. I have a special relationship, a fiduciary relationship as an attorney, one of trust. And let's suppose now I have one sister. I tell my mom, leave everything to me. I get 100%, my sister gets nothing. She writes the will. And then a few years from now, when the will is going to be executed, it turns out I inherit everything. Well, this would be an example of undue influence. If an attorney benefits from his client's action, if a doctor benefits from his patient's action, if a parent benefits from his child's action, there is a presumption, because these are a fiduciary relationship, there is a presumption of undue influence. And you're going to be able to challenge the results. So we say that the one party, the dominant party, has overcome the will of the weaker party, and it has benefited. Dominant parties must always act in good faith. If they don't, let's suppose I drafted that will and I did leave half to my sister and half to me, and that was the intent of my mother. Well, then I could prove no undue influence, but the burden would be on me, the dominant party, who received the benefit. So we can ask the question, or rather courts will ask the question, to what extent was the transaction induced by the domination of a mind or motions of the person in question, the weaker party? So as I said, in a principal to agent relationship, there can be a presumption of undue influence. Now, the next extreme, where we really go beyond merely you kind of overcome the person's will, we go to duress. Now, again, this is also part where you might see a criminal side. There is criminal duress. So if I take a gun and I point it at a cashier at a store and I say, give me the money, and he gives me the money, he acted through force or fear or threat. And I induced him to do something. I induced the clerk to give me the money. You would not say, well, the clerk is guilty of the robbery as well. That's not true. If I take a gun or I use force or fear or a threat to get you to do something, to enter into a civil contract, that's duress. And we're going to be able to get out of the contract. Classic examples of this are blackmail or extortion. If I say, well, I have pictures of you down at the no-tell motel with someone other than your wife or husband, and if you do not sell me the land that I want to buy from you for $1,000, and maybe it's worth $100,000, I will publish those pictures. I will tell your wife. Or let's suppose I know that you actually had stolen something, and I say, well, if you don't sell me the land for $1,000, I'm going to turn you into the police. A lawyer has to be very careful when he is writing a letter to a client that we do not fall into extortion. I may always remind someone who I am talking to that what they're doing is both a civil wrong, potentially a tort, but if I start to bring up the issue of criminal liability, I'm getting dangerously close to extortion and blackmail. Now, threatening to send someone to prison is going to be duress very often. Threatening to sue them simply because they didn't do what they were supposed to do, that's usually not duress. All right, let's talk about economic need. If you're in a really bad economic position, so let's suppose that you really desperately need some rare mineral to finish your manufacturing process. Let's suppose you're manufacturing batteries. We know that they're very critical to most of the new electrical cars. And you need them so desperately, so fast, that let's suppose the lithium typically sells for $1 a ton. And I come to you and I say, well, I can provide all the lithium you want, but it's not $1 a ton, it's $100 a ton. So you're in a bad position, but you need it, so you make the deal. That's not duress. But let's suppose we had a contract where I would provide you with lithium for $1 a ton. And all of a sudden I come to you and I say, yeah, I'm not going to meet that contract. Some things have come up, and I'm not going to be able to provide it. Now, typically you can sue me, okay? But let's suppose you really need the lithium right away, or you're going to suffer greater damages. So you sign a new contract with me to say, well, I will pay the new amount of money. That could be economic duress. And at that point, we might say that no, the new contract can't be enforced. You can't break one contract to force the other party into a less favorable one. We can have unconscionability, which is when you get something too unfavorable. Now, most of the time, courts will not inquire into whether it's a good or a bad deal. Most of the time, the courts leave that up to us in a free market to decide. But I would be remiss if I didn't start talking here about the UCC section 2-302. Now, I give you those numbers. They're not going to show up on an exam or anything. But if you are in North Carolina and you go to the North Carolina General Statutes and you type in a North Carolina General Statute 2-302, it will take you to the North Carolina General Statutes where North Carolina has adopted that rule. So if you ever need to cite it for any reason, that's the only reason I put it in there. UCC 2-302 says you can't have unconscionable or grossly unfair contracts. We've adopted it, but it's exceedingly rare that we enforce it. Most of the time, we leave it up to you guys, the buyer and the seller, to decide what's fair or not. Adhesion contracts are contracts where someone's in a position of overwhelming strength and they impose a contract. Here would be an example. You're crawling out of the desert. You need water. It just so happens I'm running a lemonade stand as you crawl out of the desert. And I see you crawling towards me, and you've got to sign up, or I've got to sign up. One glass of lemonade, $1. And I say, sorry, new price. It's $1,000 a glass. And you have to take it. It's simply imposed upon you because you absolutely need it. That could be an adhesion contract. Any enforcement of that would seem manifestly unfair. Okay, at that point, coming in right in at half an hour, about where I wanted, that's the chapter. I'll talk to you for the next one in a little bit.